Administration and Finance of the East India Company by Babasaheb Ambedkar. Submitted in partial fulfillment of the requirements of the degree of Master of Arts, May 15, 1915. Editorial note in source publication. The copy of this dissertation was secured from the Columbia University by Dr. Frank F. Conlon of the Department of History, University of Washington, USA, and was presented to Mr. Vasant Moon of Dr. Ambedkar Research Institute, Nagpur, in 1979. The editors are grateful to the University of Columbia, USA, for their kind permission to publish this unpublished dissertation, which is in their possession and ownership. They also appreciate Dr. Conlon's gesture of generosity and assistance of Dr. Ambedkar Research Institute, Nagpur, for making this paper available for printing to the government of Maharashtra. Part 1. Without going into the historical development of it, the administration of the East India Company may be conveniently described as follows. 1. The Court of Proprietors. It was composed of the shareholders of the East India Company, stock to a certain amount, who elect from their own body by ballot a certain number of representatives, that is 24, to whom the proprietary confide the planning and carrying into effect whatever measures may be deemed most conducive to the interests of India and England, reserving to themselves a surveillance and limited control over the proceedings of the delegated authority. The requirements of a seat and a vote in this court were as follows. A proprietor of £500 stock was entitled to a seat in this court. A proprietor of £1,000 stock was entitled to one vote. A proprietor of £3,000 stock was entitled to 2 votes. A proprietor of £6,000 stock was entitled to 3 votes. A proprietor from £10,000 to £1,000,000 and upward stock was entitled to 4 votes. Besides this, the stock must have been held for at least 1 year before voting. There was no voting by proxy, and minors were ruled as incapable of voting. The voters counted lords, commoners, women, clergy, and officers, civil and military, both of the king and the company. The sessions of the court were quarterly, March, June, September, and December. 9 qualified proprietors were quite sufficient to ask for a special session of the court. The speaker was ex officio the chairman, who presided at the session, brought forward all motions requiring the sanction of the court, and laid before the members the accounts of the company's transactions. The court was authorized 1. To elect qualified persons to constitute what is known as the Court of Directors. 2. To declare the dividends on the capital stock of the company within certain parliamentary restrictions. 3. To frame, alter, or repeal such of the bylaws as hinder the good government of the East India Company, provided they do not conflict with the Acts of Parliament. 4. To control in general any increase in a salary or pension above £200 a year or over any gratuity beyond £600. 5. To confer pecuniary reward for good service. 2. The Court of Directors. It consisted of 24 members. The directors were elected by such of the proprietors as were qualified for a vote. The qualification of a candidate for the Court of Directors were 1. He must be a natural or naturalized subject of Great Britain. 2. He must possess £2,000 stock, no matter for what previous period. 3. He must not be a director of the Bank of England or the South Sea Company. 4. He must be a resident of England for 2 years after holding office in the court. 5. He must not have held any maritime office in the service of the company for 2 years previous to his proposed election. 6. He must not have any under plea or pretense whatsoever endeavored to obtain directly or indirectly a vote for the election of himself or any other person to be a director. 7. He must take an oath: A. Not to carry on any private trade. B. Not to have any dealing with the company except as a private individual. C. Not to hold any office or place of emolument under the crown. In order to fulfill the various duties, the work was assigned to several committees into which the court was subdivided. They were 1. Secret Committee, 2. Correspondence Committee, 3. Treasury Committee, 4. Government Troops and Stores Committee, 5. Legal Proceedings Committee, 6. Military Proceedings Committee, 7. Accounts Committee, 8. Buying Committee, 9. Warehouses Committee, 10. India House Committee, 11. Shipping Committee, 12. Private Trade Committee, 13. Civil College, 14. Military College. All appointments such as writers, cadets, and assistant surgeons, etc. were made by the directors. The civil and military services were recruited from the graduates of the two colleges, which were merely a burden on the revenues of the company. 3. The Board of Commissioners for the Affairs of India, the Board of Control. The powers of the board are 1. The superintendence and control over all the British territorial possessions in the East Indies and over the affairs of the United Company of Merchants trading thereto. 2. To superintend, direct, and control all acts, operations, and concerns which in any wise relate to the civil or military governments or revenues of the British territorial possessions in the East Indies in the manner hereinafter directed. All the members of the said board, at all convenient times, have access to all pillars and monuments of the said United Command and are furnished with such extracts or copies thereof as they require. The Court of Directors are directed to deliver to the Board copies of all minutes, orders, resolutions, and other proceedings of all general or special courts of proprietors of the company and of the Court of Directors, so far as they relate to the civil or military governments or revenues of the British territorial possessions in the East Indies, within 8 days after the holding of such respective courts, and also copies of all dispatches which the directors receive from any of their servants in the East Indies immediately after the arrival thereof. Also copies of all letters, orders, and instructions whatsoever relating to the civil and military government or revenues of the British territorial possessions in the East Indies proposed to be sent or dispatched by the Court of Directors to any of the servants of the company in the East Indies. The Court of Directors are required to pay due obedience to and to be governed and bound by such orders and directions as they shall from time to time receive from the Board, touching the civil or military government and revenues of the British territorial possessions in the East Indies. Whenever the Court of Directors neglect to transmit to the Board their intended dispatches on any subject within 14 days after requisition is made, it is lawful for the Board to prepare and send to the Directors, without waiting for the receipt of the copies of dispatches intended to be sent by the said Court of the Directors as aforesaid, any orders or instructions to any of the governments or presidencies aforesaid concerning the civil or military government of the British territories and possessions in the East Indies, and the directors are required to transmit dispatches in the usual form, pursuant to the tenor of the said orders and instructions to be transmitted to them, to the respective governments and presidencies in India, unless on any representation made by the directors to the Board touching such orders or instructions, the Board shall direct any alteration to be made in the same, which directions the Court of Directors are bound to conform to. The Board of Control was subdivided into 6 departments to answer its functions. 1. Accounts. 2. Revenue. 3. Judicial. 4. Military. 5. Secret and political. 6. Foreign and public. The mode of local administration in India was as follows. The country was divided into 3 presidencies, namely Bengal, Madras, and Bombay, the seat of government being respectively at Fort William, Fort St. George, and Bombay itself. In the beginning, the supreme local administration of India was distributed among these 3 governments, each one enjoying coordinate status. With a view to centralization, The supreme local administration of India was vested in the governor of Fort William in Bengal, making the other two governors subordinate to that of Bengal, who was made the Governor General of India. The appointment of the Governor General was made by the Court of the Directors, subject to the approval of the Crown. The Governor General was aided by a council known as the Supreme Council, originally servants of the company in India of at least 10 years' standing. The fourth one must not have belonged to the company's service. The Commander-in-Chief of Forces in India was an ex officio member of the Governor General's office. This Supreme Council of 5 members was expanded by adding to it in 1853 6 legislative members who were authorized only to sit and vote on the framing of laws and regulations. 4 of these 6 legislative members were required to be the civil servants of the company of 10 years standing in Bombay, Madras, Bengal, and the northwestern provinces. The 2 remaining places were filled up by the Chief Justice and one other judge of the Supreme Court of Calcutta. The Governor General was authorized to add 2 more members to this Council of 11 under Section 22 of Statute 16 and 17, Victoria Chapter 95, but the power was not exercised at best up to the time of the mutiny. This Supreme Council of India, therefore, was composed of 6 members, including the Governor General and the Commander-in-Chief, for the purposes of executive government, and 12 members for the purposes of the legislatures. 7 members were deemed sufficient to form a quorum. The power of the Governor General was so great that he was nearly an autocrat. He could not only veto all legislation in the council, but could initiate and carry out measures independently of the council. All political appointments, including those of the residents to the native states and the commissioners to the non-regulated provinces, were made by him. He could appoint the Lieutenant Governor of Bengal and of the Northwestern Province, and the judges of the lower courts, and controlled military patronage in Bengal and the Northwestern Provinces. All districts not included within the limits of any of the 4 subordinate governments were under the direct jurisdiction of the Governor General and Council, who also exercised such power over the native states as accrued to him through treaty obligation. The official staff of the Governor General was divided into 4 departments, each one represented by a secretary. These were 1. The Foreign Department, foreign in relation to the native states. 2. The Home Department, handling the judicial and revenue correspondence. 3. The Financial Department. 4. The Military Department. Besides these, the political and finance secretaries had their respective secret departments which were entrusted with secret dispatches. The subordinate governments of Madras and Bombay were administrated thus. Each had its respective governors and councils consisting of 3 members, including the Commander-in-Chief. Both the governors and the councillors were appointed by the Court of Directors. Bengal and the Northwest provinces were each governed by the lieutenant governors who were appointed by the Governor General. The subordinate governments were denied the power of legislation or creating any new office, nor could they grant any salary, gratuity, or allowance without the previous sanction of the Governor General of India in Council. This extreme strictness, though required by law, was not required by custom. In order not to overburden the Governor General, minor matters were executed by the Governor, who submitted a quarterly report of the same to the higher authorities, who reviewed it and, as a matter of fact, sanctioned it. The Bombay and Madras governments were privileged to hold direct correspondence with the Court of Directors and did send the abstracts of their proceedings to the court and to the Government of India. The instruments of Indian government were furnished by what was and is known as the civil, covenanted and uncovenanted, the military, the naval, and the ecclesiastical service. The collection of revenue and administration of justice was regulated to the civil service. For civil and military recruitment, the East India Company had maintained 2 colleges in England. 1. The Halyburgh College, and 2. the Addiscombe Academy. Each student cost the company about £96 a year during his period of training. All revenue was collected in the name of the Supreme Government of India and was transferred to and controlled by the Supreme Treasury. There was absolutely no local fiscal autonomy. The deficit in one province was made up by the surplus in another, and the entire Indian revenue was held responsible for the debts borrowed for wars in one particular province. In short, both finance and administration were absolutely centralized, as in France under the ancient regime. So much for the pure system of administration. The criticism of it we will postpone till we come to the next chapter. The last chapter must have made it clear how and why Western Europe was at a death grapple for the control of India. We followed the armies of the different leaders of different nations, fighting for a country the people of which had very little to choose in the final destiny. The Kama, the Albuquerques, the Bussys, the Lallies, the Clives, the Malcolms, the lakes and the shores, as though enacting the trains of ghosts and Banquo's line, all that terrified Shakespeare's Macbeth out of his senses. The end.